If you're complying with the gas safety regulations, there are two things you have to do. The first of these things is to serve a gas safety certificate on your tenant before they occupy the property. Before they occupy the property, not at some later date, which is what a lot of people do. And the second obligation on you is to make sure that that gas safety certificate is updated within 28 days of it being replaced, so if you get a check done during the tenancy. And the problem with all of this is that most people don't serve tenants with their gas safety certificate before they occupy the property. They usually mail it to them later, along with the tenancy deposit protection information, and a lot of agents are guilty of this as well. This is a problem because the new Section 21 requirement says that you cannot give a tenant a Section 21 notice if you've not complied with the gas safety regulations. And it has been held both in a case in London with the very well-known His Honour Judge Luber, one of the most senior circuit judges in London. In fact, he is the senior circuit judge of London now, in a case called Carradon Properties Limited versus Monty Schultz, and more recently out in Truro with a different circuit judge, and Trecarrow House Limited in Ransfield, that this is not something you can fix. So if a tenant doesn't get a gas safety certificate before they occupy the property, then you can't serve it on them later, and in effect you can't serve them with a Section 21 notice at all, and therefore they in effect end up with a fully assured tenancy. So this is a bit of a serious problem. Now as it happens, the Trecarrow House versus Ransfield case is headed towards the Court of Appeal to try and sort this out. This wasn't intended, I hasten to add. This is not something the government intended to do. They have told me it was an accident. They could have fixed this already, in fact, because of course they've passed regulations to change Form 6A from June, and they could have actually amended the problem at the same time so that at least it was fixed for people going forward, but they've chosen not to, for reasons I don't understand, but I did get to send a really harsh email last weekend about this and managed to bash my keyboard aggressively at civil servants. So it's not fixed, but there is the Court of Appeal has potentially interfaced, because there is quite a complex issue here around the European Convention on Human Rights. It is well established that interference with Section 21 is an interference with landlords' rights to control their own property, which is protected by Article 1 of Protocol 1 of the European Convention. And while, of course, a democratic society government is perfectly entitled to interfere with that, so, for example, they're allowed to get rid of Section 21 if they consider it a reasonable thing to do, what they're not allowed to do is do so by mistake. It's generally accepted that interfering with your human rights by accident is not actually an acceptable thing to do. That's half a joke for this time in the morning. Let's hope for at least a titter for that. But it's well accepted that interfering with people's human rights by mistake is not acceptable, and so this is one of the issues that's going to end up in the Court of Appeal. Obviously, I hasten to add, I might lose in the Court of Appeal, which is a bit of a problem. So it remains a problem, but the key thing to bear in mind here, and the key point, is that you must make sure that you're serving gas safety certificates before people occupy the property, okay? Which not enough people are doing. And it's perfectly possible I'll lose, and the government has very little intention of fixing it. They're quite reluctant to fix it now. They're tending towards the view that, frankly, landlords should be serving gas safety certificates before people occupy the property. So there we are. And of course, there's not much point in fixing it now anyway if you're going to get rid of Section 21 anyway, so what the hell. But it gives me something to do.